Ladies and gentlemen, welcome to another episode of Systematic. Today I have with me Barrister Samiuddin. Barrister Samiuddin, apart from being a close friend of mine, is also a partner at Bhandari Naqvi Riaz. He's a constitutional law expert, and many people say that law is boring, but then Samiuddin decided to take that as a challenge and went into the most boring part of law, which is constitutional history or legal history, if you will. You don't like that intro?
No, it's perfectly fine. I think you're being too charitable with calling me a constitutional expert. I mean, yes, I practice constitutional law, but I'm a general sort of commercial practitioner. But I think in Pakistan, and I think we're going to be discussing today how in almost every legal matter, the constitution is sort of closely interlinked with that.
So what we're looking at, I mean, there's a reason we called you in, and that is the 27th Amendment, right? One, you're not going to find a lot of lawyers who are willing to come on our podcast for that and express their genuine views. Yeah. But we know that there's a mad streak that runs in you and runs in me, and so we're here, right? But so before we get to I think the discussion there, do you think that a constitutional amendment of the nature that this 27th Amendment was, like surgery of the Constitution, if you will, how deep it has affected judicial independence, structure of the armed forces, immunities within the framework of the president and whatnot in his office. Do you think that this parliament, with all the question marks over it, should have been allowed to do something like this?
No, I think, and that's one of the biggest question marks, other than the substantive issues with this amendment, is, the procedure, how Parliament went about not only passing this amendment, but also the legitimacy of this Parliament, starting right from the elections and all the question marks over there. I think everyone is aware. And I would say the ordinary folk in Pakistan are more aware about the problems with those elections than, the nuances of a constitutional amendment, how it affects the judicial structure. I mean, the majority of the population of Pakistan, I'd say, don't care as much as perhaps the lawyers and those who have a certain, are vested in the judicial structure. But from the start, and this starts around the 26th Amendment. This starts from there. And one of the big question marks over there at the time of the 26th Amendment was the fact that you had one entire province not represented in the Senate. You had the issue at the time, there was a Supreme Court case pending, which was the reserved seats issue, which really stems out of how one of the largest political parties in Pakistan, that's Pakistan Tehreek-e-Insaf, how they weren't allowed to run as a party. And then prior to that, a decision of the Supreme Court which took away its bat symbol. And the essence of that bat symbol has always been for ordinary folk to be able to identify who they want to vote for.
And it unified a group of politicians under a particular banner.
And under a particular banner, but mostly in order to allow, people who couldn't read to identify their preferred party and then vote for them. Because of the sort of intra-party election issue of PTI and how they conducted it, that issue starting from the ECP all the way to the Supreme Court, the Peshawar High Court and then the Supreme Court, it became whether or not that intra-party elections and defects in that, if any, could deprive them of that symbol. And then once the Supreme Court decided that yes, that meant that they could not have the symbol, you had sort of this period of legal uncertainty during the elections where the PTI politicians themselves didn't know whether they could run the elections as PTI candidates or whether they were forced to as independents.
Exactly. And that affected campaigning, of course.
That affected campaigning.
And ultimately the actual election.
And that affected even after them, to the extent they were, able to get voted in, whether they were then able to, as a party, get reserved seats under the Constitution. And as you know, that affects the numbers in Parliament. And so it all starts from there, essentially.
Of course. And it was the ultimate resolution of that in favor of the ruling party, which allowed them to have a 2/3 majority and allowed them to pass this.
Although the initial decision of the reserved seats judgment was in favor of PTI, it was sort of a full court decision. You had mixed opinions, but the majority decided that PTI could not be deprived simply because that bat symbol was taken away. And so ECP had to treat them as a party, and they should have gotten the reserved seats. Obviously, that was then later on overturned by another, and that's post 26th Amendment. It was overturned by the Constitutional Bench, which now allowed this government to get all the numbers they wanted, along with PPP, to pass the 27th Amendment. So anyway, I mean, we'll come to the breakdown of that. But yes, big procedural question marks on both the 26th Amendment and then the 27th Amendment being passed.
Yeah, it's, I mean, an unfortunate series of events. Frankly speaking, as a lawyer, somebody who's looking at this from, being part of the community, but also seeing that there were people on both sides, so many who were cheering and trying to justify the legal dimensions to this, which frankly, were quite weak at times. But of course, you're going to have, you put two lawyers in a room, you're going to have two different arguments, right? Yeah. Okay, let's get to the actual amendment. So the 27th Amendment has come in. It has shaken up a system. It has caused, I think, a lot of confusion as well, especially amongst even the legal community. They don't know how to, cases are going to be filed, especially cases which have writ jurisdiction, writ jurisdictions. How are they going to be, processed and looked at? So, could you give us, in your words, very briefly, what you think are some of the key features of the 27th Amendment that's going to really have a real impact on us?
So, I mean, it's always important to take a step back and look at the 26th Amendment, right? Because they're closely related.
That's the legal historian in you.
Yeah.
Can't look at things as they are. I have to look at them.
There's always a context to everything. And And the way this is designed, it went through a process. So, interestingly, one of the big features of the 27th Amendment is the fact that it has split the Supreme Court of Pakistan into two courts.
Okay.
So now you have a Supreme Court and you have a Federal Constitutional Court,
FCC,
and which splits the constitutional jurisdiction that the Supreme Court had. And it basically rips it apart from the Supreme Court of Pakistan and gives it to this FCC. But interestingly, this proposal was in the initial draft of the 26th Amendment.
Okay.
So they always wanted to do this.
But they watered it down.
They initially watered it down to constitutional benches. So they said, okay, let's not create a constitutional court right now. In the 26th Amendment, we'll create this concept of constitutional benches, which will consist of constitutional or so-called constitutional judges, hand-picked by a restructured or reconstituted Judicial Commission of Pakistan.
Okay.
And one that is, I would say, heavily dominated by political appointees that make up the Judicial Commission of Pakistan. So traditionally, the JCP had the majority of its members consisting of judges.
Yeah.
But then through this 26th Amendment, that got changed. So you had ultimately, out of 13 members, 5 were only judges, whereas the other 8 were either politicians from the National Assembly or the Senate, or were members of the executive, such as the minister or the attorney general, or were some members who were appointed through some political influence, right?
Okay.
So, I mean, even if you had a woman member or a non-Muslim member who was not a member of National Assembly, but they were appointed by, let's say, the Speaker of the National Assembly.
I see.
As I recall. And then you had a member representing the Pakistan Bar Council. But the ultimate point is that you had a JCP dominated by non-judges and mostly political I would call them political appointees. That carried on in the 27th Amendment, but the point, with some modifications, but the point to note in the 26th Amendment was that this JCP handpicked certain judges to sit on constitutional benches who had exclusive jurisdiction to decide on constitutional matters, which 100% of them are against the government.
Yeah.
And so it was like the government choosing judges who would hear cases against them.
So what's wrong with that? Right?
Yeah.
That's completely.
What's wrong with that?
But just examining this, what's wrong with that argument a little more? Okay, in the U.S., the president decides to pick a guy, and the person is confirmed through the Senate and through hearings like that, right? That's a purely political process. There are no judges involved in that.
Yeah.
So why is it bad? Do we have a fundamentally different legal system or judicial system that requires, in your opinion, that judicial independence would only be protected if there were judges who were nominating judges and, say, finally selecting judges or something along those lines?
So, yeah, I mean, in the US, you do have a purely political appointment process. But I believe over there, judges don't retire, so they have security of tenure.
Yeah.
And I think that's one way how they offset, the judicial independence issue.
Yeah, they either die or they go mad.
Yeah.
That's
and although they come in with a certain level of influence, they'll have a conservative leaning or a liberal leaning. But at least once they're there, there's no interference.
Yeah.
So the thing with the 26th Amendment was that these constitutional judges were there for a particular term.
Oh.
And you had the JCP,
Yeah.
the executive, political dominated JCP, that could just decide not to reappoint them. Say, oh, we don't like the way you've been deciding for the past 2 months against us.
Okay, wow.
We can choose another bunch of judges to hear our case. In the 27th Amendment, that isn't an issue anymore, but they've done another thing. What they've done is the new batch, so the Chief Justice of the new Federal Constitutional Court and the new batch of judges, they are handpicked by the President.
Really?
So no JCP to start with.
Oh, wow.
Yeah.
Okay.
And that obviously sets the tone of how further appointments will be made by the JCP or the future Chief Justices that are appointed by a special parliamentary committee. So that's interesting as well. Just like the 26th Amendment, the 27th Amendment holds on to, keeps that committee of purely parliamentary members that decide who will be the Chief Justice of now the Supreme Court and the Federal Constitutional Court. Yes, they get to choose from the 3 senior most members, but they get to choose who's the best out of the 3 for them, right? For the government or who. And then those Chief Justices get to sit on the JCP. So, they already have, and one might argue that they have a certain leaning towards, what the government would like to see on the court. And so the JCP now, even though slightly modified, again, similarly, mostly dominated by political appointees. The other thing that you have to keep in mind when we're comparing with other jurisdictions is that the way our law has developed. So we started off with the president, on the advice of the prime minister, appointing the chief justice and judges. Don't test me on my constitutional history on that, but obviously we all know that in the cases, or in one of the major cases the Supreme Court decided in the Rawalpindi District Bar case, that related to, if you will recall, the 21st Amendment.
Yeah, absolutely.
Where POPA,
POPA, military courts and all
military courts was at issue.
Yeah.
In those cases, the court also decided the validity of the 18th constitutional amendment.
Okay, wow.
And the 18th Amendment created the JCP, but also a parliamentary committee. So the JCP, mostly judges, would recommend to the parliamentary committee, and then the parliamentary committee would then approve or not. But what happened was the matter came first in another case before the Supreme Court, and the Supreme Court said that this prima facie looks like it is is contrary to judicial independence. And so they slightly tweaked it, Parliament slightly tweaked it, and what they did was, parliamentary committee can't say no, but it can send it back and ask the JCP to reconsider. But then if the JCP sends it again, the recommendation, then that judge will have to be appointed. But in the district bar case, when the validity of the 18th Amendment and then the 19th Amendment that made that slight tweak was being tested, the majority of the Supreme Court held that, to the effect that the JCP needs to be mostly consisting of judges. They are the best to decide, who is best qualified.
Yeah.
And also to maintain that judicial independence. Now, that might not be the case in other jurisdictions. I mean, I believe in the United Kingdom, they have, and I don't know about their superior judiciary, but their judicial commission consists of, I think, the majority of members are technocrats.
Okay, well.
Civil society.
Yeah. And they're not necessarily.
Not necessarily, but it works for them, and they have other checks and balances in place. But here we have a decision of the full court of the Supreme Court saying, this is how it has to be when it comes to appointment of judges. What this 27th Amendment does, interestingly, it makes two other amendments. One in Article 239, which used to say that the Constitution can be amended, and it cannot be called into question. But the Supreme Court had always interpreted that in a way to say that the Supreme Court can always look at constitutional amendments if it violates, the salient features of the Constitution.
Basic structure.
Well, it chose not to use that word, which was used in by the Indian Supreme Court. But it just gave it a different name, like salient features. Essentially the same thing. But basically, democratic principles, separation of powers, judicial independence, stuff like that. Now, in the 27th Amendment, they've introduced, I think, a provision which says you just simply cannot call into question any amendments.
Shut up.
And there's something to the effect that even I forget what the language is, but in effect it says that even a judgment of the court, won't affect whether or not you can challenge a constitutional amendment. I forget what the language is. But ultimately they negated the district bar case.
Wow.
Of the Supreme Court.
I see.
And they've done another very interesting thing with regard to the power of the FCC, the new FCC, is that they've said that all decisions of the FCC will be binding on all courts. And similarly, all decisions of the Supreme Court will be binding on all courts except the FCC.
Okay, wow.
So they've sort of created this hierarchy where the FCC sits slightly above the Supreme Court.
But theoretically speaking, we are talking about two different. I mean, we're talking about the Supreme Court that takes pure appeals, right?
Yeah.
And we're talking about the FCC that takes constitutional matters, writ petitions, this and that. So they should be fundamentally different subject matters.
Yes, except
but ultimately everything is constitutional, is it not?
Yes,
that's the issue.
And that is one of the other issues that a lot of people that wrote about the idea of an FCC, of a constitutional court, from a purely academic point of view is, and whether or not it's workable in a country like ours, right? Yeah. We are known as a common law jurisdiction, obviously, because we've inherited that from as a former colony, British colony.
Yeah.
And constitutional courts are usually found in civil law jurisdictions. So Germany, France,
much of the Arab world.
The Arab world, or at least that part which were colonized by the Europeans. And so, and a lot of this is linked to the idea of judicial review and the power of judicial review. So in the civil law countries, there was no such thing as judicial review. So whatever Parliament enacted, you just had to follow that. And this is my understanding of it, that they never thought that the courts could actually sit in judicial review of legislation and question whether or not this infringes some higher principle, some constitutional norm.
Yeah.
And then obviously you had, dictators coming out in Europe as well. And so I think that led to the development and the idea of a constitutional court that could sit separately and assess, okay, is Parliament exceeding its limits?
Yeah.
Is it, contravening the Constitution itself? And so it's workable there where you have a separate system entirely. In our
also
country,
judicial review of executive action. Right?
Yes.
And that's what this court would also have a view of.
Now, I'm not sure whether their constitutional court deals with judicial review of executive action. They might just have separate administrative courts for that as well.
Yeah, that's also...
but you see...
Yeah.
But here, our courts of general jurisdiction were always thought to be able to deal with all types of rights. Now, through the creation of this constitutional court and the way they've done it in the 27th Amendment, there are question marks on certain cases as to who will, decide them. So, for example, the 27th Amendment makes a change that appeals arising out of proceedings under Article 199 of the Constitution before the High Courts, they can only be appealed before the FCC. But what it doesn't take into consideration is that the High Court under Article 199 doesn't only deal, and in the majority of cases does not deal with constitutional issues or constitutional interpretation. So in most situations, it's dealing with a statutory violation.
Yeah.
So there's no constitutional issue there. So why does this need to go to the FCC?
Could it...
Right?
Yeah.
So especially when you have all the other provisions which seem to suggest that the FCC is meant to only deal with issues of constitutional interpretation.
Yeah.
There's one interesting other thing they've done, mostly designed at sort of, not letting the Supreme Court touch any constitutional matter. It's sort of like, is one of the sub-clauses in Article 175 F or E, I think, which gives the FCC its original jurisdiction, is that the FCC can now simply call up the record from any court,
including the Supreme Court.
And I think that will be read as including the Supreme Court, although it's with a small c, but it'll be read as that, if it feels that there's a constitutional issue involved. And so if it sees over there,
that's the vaguest...
Yeah, and so you might have a criminal appeal before the Supreme Court where someone being tried for, let's say, a PECA offense, right? Prevention of electronic crimes. Maybe some journalist or some human rights activist is being prosecuted for saying something that the government doesn't like, something on Twitter or X. And the only issue is about how that trial is being conducted and whether it's being conducted fairly or not. Now, ordinarily that would go up through, first probably to the High Court, then the Supreme Court. But FCC, if it sees, we don't like the way this is going, it'll just summon the case and say, we're going to decide on this.
Wow. That's... Sami, let me ask you a few questions, okay? I want to play devil's advocate here as well.
Okay.
I think somebody needs to speak in favor of the 20. No. But what I'm saying is, look, we've had
I think we should have an objective analysis of whether FCC can
Look, I don't know
work.
about objective, but I'm playing the devil's advocate here. Okay. These are not views that I hold.
Yeah.
Okay. The judiciary in Pakistan has unfortunately had a checkered past, right?
Yeah.
There have been judicial murders, the very famous, infamous, Bhutto case, which was, posthumously rectified recently. We've had the judiciary, give approval to military dictators, and we've had so much go on that. We've had judicial apathy in, very severe human rights abuses that have taken place. Why should anybody care if the judiciary is being cut down to size, right?
Yeah.
That's one argument. The second is, whenever there's progress or CPEC needs to be, or Metro, Orange Line, whatever these are called, who gives stays and who stands in the way of progress? It's the judiciary, right? And sometimes those are justified, but many times they're not justified, right? And it's just because there's a vakil from a big name and he's gotten the case, taken a lot of money for it. That's why he has to.
Yeah.
Then there is judicial. So if the judiciary's cut down to size, and if they've now become an extension of a state which is progress minded, which wants to get things done and remove things, why is it a bad thing?
Yeah.
Right. Again, not my views, but anyway. So, what would be your response there? That why should we care?
Yeah.
One, and secondly, they're getting their just desserts to an extent, right? Is that a fair assumption to make? Or
those are very compelling arguments, I'm convinced. No, look, I've shared the same sentiments when it comes to the judiciary, some of its interference in places where it had no business. If you look at some of the decisions even by the Supreme Court which affected the economy of the country, whether it's big international investment related issues, RICO-DIC, everyone talks about that.
Yeah. Pakistan Steel Mills.
Pakistan Steel Mills, rental power cases. All of these arose out of some form of interference by the Supreme Court, and unjustified interference. Yeah. Although, I won't go into the motivations of the particular judges who sat and the Chief Justice that sat and took suo moto or whatever. Maybe it was their lack of understanding of international law or international commercial law, and they thought they were doing something good for the country. But in most cases, I would say they were well aware of the abuse of the power of the Supreme Court, right?
And yet they took those...
And yet they made those decisions, yet they interfered. Even when it comes to political issues, Panama.
Yeah, absolutely.
Everyone thought, we are doing a great thing. It's going to clean up politics from then on. But it wasn't much of a fair hearing. And
frankly, it was an abuse of the judicial system.
Yeah,
that's what it was, right?
And even if people felt that the end result, this is what I have the problem always with. The idea of the ends justify the means.
Yeah.
So that I think that analysis is right, but the problem is at the end of the day, it's not the judges that are the losers; it's the common man. It's not even the lawyers. Trust me. I think we'll adjust. I think all the commercial lawyers will adjust. Those who are upset about the FCC, they'll adjust as well. Life will move on. The issue is that your ordinary folk who might have a genuine grievance against the government and who file a petition looking for a fair-minded, impartial, independent judge to hear his case or her case, and to be bold enough to pass a decision against the government and all the might that stands behind the government, to come, to give justice to that petitioner. That is the real issue at stake. And so, let me talk about this pro bono sort of public interest litigation that I did, Afghan refugees. No one wants to talk about Afghan refugees. But,
except for traitors like you.
Except for traitors like me. People, surprisingly, and I guess not so surprisingly, but a lot of people, ordinary people in Pakistan, see it as a traitor issue, see it as, whether you're a patriot, see it as, you're supporting the Afghan government, or see it as you don't want peace in Pakistan. It's not about that. It is about the principle that if you have refugees in your country, even if they haven't been through a legal process where it is determined that, yes, they're either proper refugees or they're economic migrants, you cannot simply pick them up and kick them out.
Yeah, especially when they've been here decades.
Well, I wouldn't even say decades. Even if they've been here for 5 days. But if they come as a refugee from another country, you cannot, without undergoing a judicial process, determining whether this person is actually a refugee or whether they are, an economic migrant, or whether they're just an alien who has no basis to be here. You can't just chuck them out. Why? Because the idea behind being a refugee is that you've just fled from persecution. You are at risk of, your life is at risk. You are at risk of undergoing, torture or some other major fundamental rights violation. And that's the idea behind, not returning refugees.
So in this,
but the point is that which court or Supreme Court or which Federal Constitutional Court or High Court is going to take up that issue, where it's not only against the government, it is against, it involves a security concern as well.
National action plan.
But which fair-minded judge is going to look at that? Especially if they're not impartial, not independent, and say, okay, there is no real security concern, there is a fundamental rights issue, don't kick this refugee out now, or don't kick out millions of refugees altogether, and Parliament should enact some law, let's have a process so that we can determine whether they are actually at risk. So sort of these kind of issues, and there are many more if one sits down, but so the question is, how will these issues be decided in a post-27th Amendment environment?
Look, with regards to, say, the Afghan refugee issue, what I found to be particularly distasteful, really, disappointing, was the fact that human beings were used as bargaining chips in a political thing. Right? That ultimately rights and things that we give value to in our legal system, or at least in a constitutional understanding of where human beings lie and where the role of the state is. That in that we used this large group, it's not a small group of people, and we, equated them as simple bargaining chips and nothing more. And that I found to be, really, really, we're better than this, And then you see situations like the 27th Amendment being passed where now there's no recourse, or at least theoretically there is the recourse, the option of you having judgments that saved the little man, or protected you against the state, or protected rights over the state's whatever its position was. I think those days are over now to an extent, right? That you can appoint. I mean, you can still theoretically have those, but for a judge to maintain his position on, say, the FCC, and with the power that now Parliament, but basically the executive now has over the judiciary, a lot of that has gone to hell.
Yeah.
Right. And that is something that I think raises a lot of the fears and a lot of the concerns that there's a really famous saying which I love, and I think that describes it here, and it also describes some of the judicial activism. And you're too good a man to take their names, but I have no qualms about this. Saqib Nisar, Qazi Faiz Isa, these guys, there was something about the chair that gave them a strange strain. But the saying that I think it's U.S. Supreme Court Justice Robert Jackson, we are not final because we are infallible. Yeah. We are infallible because we are final.
Yeah.
That, if you want to take experiments, do that at a lower level.
Yeah.
But once you're Supreme Court, you're the chief, you are it. And beyond, there is no rectification of the mistake that you make.
Yeah.
Be a lot more careful with what you decide, right?
Yeah.
And that is something that I think these judges have really not been able to look at from that, or haven't really cared about.
Yeah.
And I just don't understand what it is at that level when you're looking at it from that particular seat that changes in you.
Yeah. I mean, it really is the seat, isn't it? It's that all that power that you have.
Otherwise, good men corrupts them, right?
I mean, it's definitely not an easy job.
Yeah, for sure. I think the stress level must be.
But there's nothing forcing them to take on the job either. So if they're there and they take on that responsibility, they owe a duty to every single person in the country to do right by them. Yeah,
and these aren't men who are destitute and that they depend on the job, right?
Yeah, of course.
As in Qazi Faizi's case, all too openly we now know that he's not a destitute man, right? And similarly with Saqib Nisar, with others as well, right? This is them making a conscious decision.
Yeah.
That these are the decisions we're going to stick by.
I mean, look, it makes the question and the debate about having foolproof mechanisms in place or systems in place, either in the Constitution or the law, to ensure, at least for the majority of the time, that whoever you have as judges, they're able to perform their function in a fair manner, with independence, not being influenced by anything, whether it's being financially corrupt or whether it's some other pressure on them, which I feel it's just so important for debates about constitutional design being really or having such debates at the really lower level, not just the elites, not just those who have gone to nice universities or the black coat, black tie lawyers. I mean, what do the ordinary folk think about what type of people and are chosen to decide their cases, and how should they be selected? I mean, I don't know. I would really love for someone to take this on, but I don't know what they think. Like when jargas happen from the part that we come from, let's say KP, the Pashtuns, or from Balochistan, or panchayats in Punjab, would they accept that the elders on the jarga that sit are family members of the opposing party? I mean, it's basic common sense, isn't it?
Yeah.
And so, I mean, there are a lot of other academics who've written about this in Pakistan and doing great work. And I think, getting them to jump on this is good as well.
Sami, is this the natural progression? Progression is the wrong word. Regression of a state into banana republichood? Because we've seen so many other countries that who have rubber stamp judiciaries, right? You want to hold somebody up for terrorism, you want to give them the death penalty, this and that, you put them in front of a judge, you get the result you want, right? Is this the bananification of of the judicial system in Pakistan?
Yeah. I mean, we've been accused of that for a long time, right?
Yeah,
Pakistan has always been said, oh, it's a banana
this
republic.
This is simply
republic.
the crystallization or the formalization of something that's been happening for a while.
We've been through a number of coups, military dictatorships. By the way, a lot of stuff that we're seeing now, there happened back then as well. Not like this. I would say this is like a PCO on steroids.
Yeah.
A much sophisticated, advanced.
We learn from our mistakes.
Yeah, we do. We know how to dismantle the judiciary now.
Yeah. We're specialists.
Yeah. I mean, before you had PCOs that would replace judges.
Yeah.
Now they've just replaced the entire court. So, but I mean, I don't know. Sometimes I'm a bit of an optimist. I think that we will bounce back. Mm-hmm. It just has to go through a certain process. Something just needs to shift, and then, it just requires for everyone to get on board, to realize what's happening. Yeah. And otherwise it will get really, I mean, we were talking about refugees. I just wanted to share, like, it can affect other parts of people's lives as well, right?
Of course.
The sort of this security mantra of the government, and when it comes to the internet and firewalls and 5G warfare and disinformation online. I mean, these are real issues as well.
Yeah.
But also the basis of a lot of abuse and, I mean, sort of state repression. And we need judges to be able to be independent to deal with these kind of issues.
Yeah, absolutely.
Yeah.
In fact, it's our last bastion or last hope, really, in the overall system, that it will be the judiciary who will stand up for us when nothing else can.
Although, I mean, I have a lot of colleagues who talk about that, look, we need to think beyond the judiciary. I don't know, maybe...
They've already written the obituary, they've already settled with the fact that...
Yeah, maybe some civil rights movement, or something else. But, and maybe it's not just reliance on the judiciary if one wants to fight for civil liberties.
Okay, so explain to me what a post-27th Amendment judicial system, not judicial, but legal system for us or world looks like, right? One of the biggest issues that you've had, and I've always felt this, is in a country like Pakistan, with the population that we have, with the inequalities that we have, with the elite capture that we have, the judiciary was a vent that, instead of you going out on the streets and spilling blood, you could do a case and you could, get some sort of satisfaction or redress of your grievances there. And that this was something that, you had faith in the system that it could maybe, plan line, you could get something off. That door seems to have closed now, right? That and if you've closed the valve on that, the pressure is going to build up. And at some point it becomes, unsustainable, unmanageable, and it becomes violent.
Yeah.
And that is what the concern here is, that if you don't have things like the judiciary, if you've manipulating elections, if you don't have any of these vents where natural human emotions or human concerns can boil over or can be vented, you lead to what you're trying to avoid in the first place, which is violent protest or some sort of revolution, if you will. Do you think that's what we're maybe headed to?
I mean, I don't think that, and I'll tell you a reason why. Because I think whoever designed the 27th Amendment, the government, whoever, behind it, they also wanted to create a system which is workable. I'm not saying it's going to be. Time will tell. I see a number of issues. But also a system where they could show some performance. So, I mean, I see the FCC working, giving some relief very strategically in matters that don't really affect the government as such. So, I mean, when it comes to, let's say, political rivalries, right? Qaidi 804 or Imran Khan, his family, his lawyers being able to visit him, that might not happen, that might continue the way it'll continue. But if you have other genuine issues of public importance, genuine cases arising from the High Court, you might have judges, give relief to, petitioners and ordinary folk as well to make it look like there is some semblance of justice. But the problem is the control.
Yeah.
The fact that it will be based on their whim, it will be arbitrary, it won't be backed by, a fair, independent system. It'll be just them deciding, okay, we'll give this one. We'll decide this one. It doesn't have any major implications. Doesn't affect the government too much.
But whenever they don't want to, they could decide the other way.
Whenever,
right? And so,
let's say there's a lot of revenue at stake.
Yeah.
Let's say the government, through Parliament, enacts some new tax law, or decides they want to do something to generate a lot of revenue.
Yeah.
I don't know, acquisition of land for some development, which is terrible for the environment,
the local indigenous community,
the local indigenous community or whatever.
Yeah.
I mean, just look at what's happening in Islamabad.
Yeah.
I believe what's that hotel up on the Margalla Hills? Munal. Yeah. I mean, it was stopped and now it's back on running.
Really?
I mean, well,
I don't know.
I mean, people are trying to get it
Okay.
back on running. I mean, I understand that, rules are being bent again.
I see.
So I doubt that, where there'll be some interest of the government, where they think it's okay to cut down a few trees, then it'll be okay. So, yeah. But I mean, we've just spoken about the FCC and judicial appointments. I mean, the 27th Amendment does a whole lot.
Yeah, that's where I want to get to, some of the more fun and dangerous aspects. All right, so we've talked about judicial restructuring. Let's talk about immunities.
Yeah.
Right. So it gives.
But before immunities.
Okay.
Before we get to the really juicy bit for you, for us lawyers, it's all about the courts and the judges. One thing, I mean, I do want to talk about, and this makes it just shows how egregious this amendment is what they've done in respect of transfer of judges. So now what they've done is they've introduced provisions whereby this JCP, again, executive dominated, can just say one day, oh, we'd like so-and-so judge in the High Court to get transferred to another province.
Wow.
And this time, they do not need the consent of that judge. If the two Chief Justices of the High Courts, they sit on the JCP as well, and it's that JCP by majority that decides, that's good enough. Now what's interesting is...
And if the judge refuses to go?
Okay, now yeah, that's
the
fun part. So if the judge refuses, then somehow that is a disciplinary issue, amounts to misconduct, and it'll be referred to the Supreme Judicial Council.
And so you could be dismissed from service for that.
I mean, but so one, it doesn't say why there is a need to transfer judges. I mean, like, why do you need to transfer judges? If you were, you were making this.
If you had the best of intentions. Right?
If a judge is good for Islamabad High Court, then he's good for the Balochistan High Court and any other High Court. Yes, I agree. But if he's not good for the Islamabad High Court,
then he shouldn't be good for any
then
other
why
court.
is he okay for the Balochistan High Court? He should then just not be a judge if he's not good. But why do you need to transfer people?
What if he's a judge who's really pro-government minded and in a far-off province and he needs to be brought to Islamabad?
Yeah.
Right. Anyhow, we shall
So that's one. Yeah, that's another interesting thing with this 27th Amendment. But now the immunities bit. You really want to talk about that?
Yeah, I mean, so the president gets immunity for life.
Yeah,
this is doesn't seem crafted for an individual at all. Like this seems like a genuine need that a president needs. Like presidents need immunity for life, right?
So I mean, look, previously the president and I think the governor, they had immunity while they were in office, right? And this is sort of like settled principles that, certain heads of government, of state and of a province, you don't want to bother them with lawsuits and stuff like that.
Mm-hmm.
That doesn't mean that if they've committed a criminal act, they can't be prosecuted.
No, of course, yeah.
But I believe what would happen is that they would be removed from office, and then you would
so like an impeachment process,
like an impeachment process,
or they would have to wait for his term to end, or her term to
Although end. But the right thing would be to impeach them, and then,
but that's then a political issue, right?
But now what they've done, and I think there's a lot of sort of drafting errors in this new provision that they've introduced. So one, they've said, okay, the president has immunity for life.
Mm-hmm.
Only the governor doesn't. So I think maybe the governor can file a petition for discrimination in the FCC and say, okay, why don't I get it for life? But then there is some provision which says that no criminal prosecution or no arrest can be made. And then there's another provision that they've added that these don't apply once he has left office. So I think there's some language in there which I read to mean that after he's left office, you may be able to
do criminal...
not do criminal acts, but prosecute him for a criminal act that he might have done. But again, that for life bit is confusing. Like, why add for life? That seems inconsistent with the idea that you can prosecute him after he's left office. So I think there's a bit of
certainly
confusion.
It can't mean that you can't prosecute him for crimes he's committed after he's left office, right? Like if he goes and kills a man after retiring,
then there's no question.
Right.
Look, it's mostly designed to what he has done while
previously,
in office, right?
The good old days.
Yeah, but why they introduced for life, I don't know. And maybe the intention is that even after he's resigned, or left office, he can't be prosecuted. But it's a poorly drafted provision.
Yeah. That's a hallmark of some of our laws, sadly. Even though, generally the Constitution is well drafted, I would assume. There are provisions of it which...
the original one was.
Yeah, the original one.
But you had a series of amendments that caused a lot of confusion, especially when you had military dictators requiring...
Now, I'm going to ask you about, another aspect of this. And like Barrister Akil Malik, you're welcome to not answer them on the grounds of that these are national security concerns. So it is the restructuring... Did
he actually say that?
Oh my God.
Barrister Akil Malik is the...
Minister of State.
Minister of State for law?
I think so, yeah. And so, he was asked, and repeatedly he said, these are national security issues, that's why I can't discuss them. But it's a...
He can't discuss a constitutional provision?
Constitutional amendment. This was before the amendment took place.
Okay.
And he said, I can't discuss it because, this concerns... So, but I'm talking about the restructuring of the armed forces, right?
Right.
And the position that's been created, Chief of Defense Staff, and, we've seen similar changes in our neighbor. India has had... such a thing. You're also elevating a lot of these positions. You have at the moment a field marshal, which is the highest rank that has ever been given. So keeping all of that in mind, right? What do you feel that this restructuring, does it do anything? Is it person specific? Is it going to be, is it going to be workable in our environment? And of course, you're not a military expert. I don't expect those.
You're the military expert. You have more expertise on these issues than I do. But look, this certainly has an impact on civil-military relationships, right? Okay. And when it comes to our armed forces and their internal structuring,
Yeah.
and whether there is a need in modern times to have this structure, I believe that to the experts, right? And if they feel the need that this enables them to
be more tactically ready, or be more ready to
ready
fight.
for India or whatever,
then
that's fine. But on an objective analysis and first principles basis, having only your chief of army staff as the chief of defense, I don't know, it sort of seemed to me as, tilted heavily towards the army. How does that affect the other two defense
Wings
forces?
of the armed force,
Wing. I don't know. Maybe
now 3, because you've got your strategic command as well, right? Which has become almost a distinct
armed force. Has it?
I mean, in the sense that you have now. So there'll be the chief of defense staff. Then you have the vice chief of army staff, which is basically the army chief type thing. Then you have the air chief and you have the naval chief, and then you have
a separate
chief of the strategic force, which looks at your rocket force, but also your nuclear.
Have they made that in the Constitution?
Yeah, I think so. Yeah.
Really?
Yeah, I'm pretty sure.
Okay, we'll check that later.
We'll check that later. But so having this, and this obviously has implications for your nuclear doctrine and your national command authority and all of those things. I'm not too concerned about that. I think the guys who fight wars, they know how to fight wars.
They know how to fight wars. Absolutely. And one should. I think the issue is, I believe what they did when they amended Article 243 is they also gave similar immunity, I believe, to the field marshal as the president has.
Okay.
So that really raises the question, why was that felt necessary? I mean, any top office holder, if they're guilty of a crime, they should, face criminal prosecution. And according to their own military laws or whatever. The other thing that was interesting in there was removing, I believe, the field marshal from office, which requires a 2/3 majority.
It's like a formal impeachment process.
It's a formal impeachment process, similar to removing the president. And then what is further interesting is that once the government, let's say, wants to give a general that title of field marshal, the government can then also, even after retirement, determine his terms and conditions. Right? So you can have a government appoint a field marshal. That field marshal can continue even post-retirement, and he can have duties. Okay, well and good. He gets to keep privileges. He remains a general in office. But in order to remove him, there's this higher threshold requirement. Now, for me, and in our context in Pakistan, that sort of sends alarm bells ringing. Is the government, what does this amendment give to the government a power of some sort to,
bind other,
to use this to grant on a particular, general this title, and to have him stay, in that position, which even future parliaments, if they want to have him removed for whatever reason, they will have to overcome a pretty big hurdle. I mean, why have this in the first place? It doesn't make sense to me. I mean, but that's the problem that you have with both the 26th, 27th Amendment being so rushed. I mean, the 18th Amendment went through, a very sort of well thought out, detailed process. It went through parliamentary committees. It was debated.
Yeah, heavily.
The 26th, 27th Amendment, I mean, it also looks like a shoddy job. And it's been done overnight.
And look, clearly, I mean, the way it was done just seems like they were hiding stuff. They didn't want things to come out. National security concerns. You can't even talk about it openly. You're putting it into the Constitution, but you can't talk about it.
I mean, this reminds me. Sorry to cut you. But I think it did go to the Senate committee, and there was a bit of a debate, briefly, the 27th Amendment.
Mm-hmm.
And this just reminds me, a friend mentioned this to me, that the Senate committee report on the 27th Amendment discussed some of the provisions relating to transfer of judges, particularly the one that we spoke about, that if they refuse a transfer, then it'll be a disciplinary issue. Now, before this, the proposal was that if they refuse a transfer, then they'll be deemed to be a forced retirement.
Okay, wow.
So that forced retirement, by the way, is still in place for those judges of the High Court and the Supreme Court who don't accept an appointment to the FCC. So it's like, okay, you're in the High Court, you're in the Supreme Court, but if we want you to sit on the FCC, you better. Otherwise, you're deemed retired. But hold on, it gets better. Okay. The Senate's committee report, one of the members mentioned that this forced retirement provision would cause problems or issues of judicial independence. So they acknowledge it, but they retained it when it comes to the FCC appointment. They took it away when it came to the High Court judges transfer. Yeah. They replaced it with something even sweeter, which is, we'll send you to the Supreme Judicial Council. So anyway, we were talking about this being well thought out and debated or sort of published for the public to comment.
God forbid. That democratic process take place. No. But
can't have that.
Yeah, I mean, my overall, the feeling that I get, it's just the process certainly has left a bad taste in the mouth, and the end result, time is gonna tell. But it doesn't look rosy. It doesn't look. As somebody who believes in constitutionalism, somebody who believes in, say, the democratic process and those things, we've really left high and dry. And it is a huge concern for, say, human rights, which is my personal issue, right? That in the small man, the individual, when he takes on the state, what you had going was at least a somewhat semi-functioning judicial system. Yeah. But if you're going to skew it to one side, you're going to become another Egypt. You're going to become another, for lack of a better word, a banana republic, right?
Yeah.
And that's what the concern is right now.
Human rights and federalism. I mean, look, the idea behind our sort of structure is that all the provinces, provincial autonomy. Yeah. And this 27th Amendment, in terms of the judicial restructuring, especially the transfer of judges, it affects the idea of federalism as well. If you have a judicial commission, and by the way, for every appointment of a provincial high court, the judicial commission looks different. So there'll be the Chief Justice of a provincial high court that will sit on it, certain other members that represent the province. Mm-hmm. And so the idea is that your high court judges of a certain province are appointed, by a mix of various members, but include some provincial representation, and they are appointed as a provincial or Islamabad territorial high court. Mm-hmm. But as soon as you have then this power where you can just chuck one high court judge, take him away, you're not recognizing, you're treating it as like an all Pakistan government service, a bureaucratic system where you can just pick up one bad boy, chuck him to some corner of Pakistan because he's been behaving badly.
And does this also change, would this also not impact which judge gets to hear which case? That in the middle of a case you just transfer a judge somewhere?
That is the crux of it.
Yeah.
This whole thing, it's something very, I remember during the 26th Amendment, I think it was Bilawal Bhutto that just said it blatantly on TV that, Justice Mansoor Ali Shah, I believe, he said that, he was difficult to control. And so and he said something to that effect. It's there in the news. I don't know if I'll get sued for defamation, but I don't care. But he said something to that effect. And so, I mean, it's sort of an open secret that everyone knows that it's because certain judges were giving decisions, whether in the High Court, even in Islamabad High Court, that were just people weren't happy with, people in government weren't happy with, people in power weren't happy with. So this whole design is first to sort of kick out certain judges and make way for judges who won't rock the boat.
I think that's probably one of the biggest tragedies of this whole thing, losing, good judges. Ataminallah, Smash, Shah. These were, in my opinion, very good judges. And of course, people can critique some of their judgments, some of their ideas, but overall, I think they had their heart in the right place with taking good decisions. Samiuddin, thank you so much. I think there was, if we had more time, we'd have a lot more to discuss. Maybe we can have you on again when, if you're still a free man.
If there's a 28th Amendment.
If there's a 28th Amendment. Brilliant. Anyway, thank you so much.
Thank you.
Thanks.
The revolution will be live.